Assalamualaikum warahmatullahi wabarakatuh. Dear ladies and gentlemen, thank you for the chance that given to us to present our paper. Before I start our paper, let me introduce myself. My name is Muhammad Adjie Nugroho, as an author and presenter in this paper. And with my partner, Mr. Reza Syariffudin Zaki. Uh, he also as an author in this paper. I would like to present our research entitled Legal Protection for Consumers in Financial Technology Services. Uh, in this case, I take from the case study of PT Jouska Financial Indonesia. Let's begin to the introduction. In 2020, there are financial planning companies that not only carry out activities to provide education about finance investment, plan a strategy and financial investment goals, help achieve financial investment goals that are currently needed by consumers, investment consulting, and provide solution to financial problems. Consumers, but also he issued investment programs, transacted buying and selling portfolios, help manage and place consumer funds in certain investment instruments. PT Jouska Financial Indonesia, which is a financial planning company, has committed irregularities against the aims and objectives of the company from being a financial planning company to acting as an investment manager. For the irregularities that have been committed by Jouska, consumers who use Jouska services suffer losses because Jouska has placed consumer funds haphazardly. In this research, the study uses a normative judicial method where the author examines library materials or secondary data, which may include primary and secondary legal materials. More specifically, this research uses juridical norms, namely legal research that is limited to the norms contained in the legislation. Now we start the result and discussion. Um, Legal protection is defined as providing protection to individual interests that are protected by law. Protection aimed at consumers in the business world is seen as both materially and formally increasingly important given the increasingly rapid movement of technology as the driving force for producer productivity of goods or services that will be produced in achieving the goals of a business. Business or services in financial sector have become a business that is very vulnerable to various harmful actions by irresponsible persons by utilizing the existence of technology to carry out an action, be it fraud or abuse. Those result in losses for the users of these services. Financial technology service providers who have registered with the Financial Services Authority, we known in Indonesia as an OJK, in carrying out their business activities have several restrictions. One of which is that they are not allowed to carry out business activities outside those stipulated in OJK regulations, are not allowed to act either as lenders or as recipients of the loan. Then it is forbidden to provide information that is not accordance with the applicable provisions, and there are many other prohibitions. The existence of these restriction itself aims to create a legal protection for users of fintech services. Organized found to have violated the established prohibition will be subject to administrative sanctions in the form of written warning, fines, restrictions, and on the activities of a business and revocation of business license. Online business or electronic transaction, especially the financial technology services business, is related to law number 8 of uh, 1999 concerning consumer protection law. People who become consumers in the activity of buying and selling products, goods or services online, or who make payments via the internet must be more careful and selective and must obtain a form of legal protection to be able to avoid various threats of loss by business actors, fraud, and other crimes that often happens in online business, especially in the field of transactions with digital media or the internet. Supervision and also business regulation in the field of financial services in its implementation must pay attention to regulations related to this field, namely Law Number 11 of 2008 concerning information and electronic transaction in conjunction with Law Number 19 of 2016 concerning information and electronic transaction law. Uh, Also, Law Number 8, 1999 concerning consumer protection law and other related regulation. The use of financial technology itself consists of creditors and debtors. The requirements given must be rational to be applied to consumers or customers. In terms of legal protection that needs to be regulated to assist the development and use of online business, especially financial technology services. The first is from the perspective of the organization or business actor, customer, or consumer, the product that is the object, and the implementation of the transaction itself. The problem that are inhibiting factors for the development of online business are the validity of agreements based on the civil code, online transaction dispute resolution, and the absence of an institution that can guarantee the existence of an online store or what is often referred to as the online shop. The implementation of providing legal protection for consumers, organizers, or business actors who offer goods or services through digital or electronic system, it advised to provide all forms of complete information both regarding the terms of the cooperation contract or the product to be offered. This type of online business engaged in financial services or fintech is also regulated in articles number 65 and number 66 of law number 7 of 2014, which regulate trade. This law also provides legal protection for online business actors, for online business operators who are found not to include correct and complete information related to the requirements or goods and services to be offered. They will be subject to sanctions in the form of revocation of business license. This is to if this is to avoid fraud that might occur, or this crime called cybercrime. In the case of Jouska, the regulations used refer to the provisions in the capital market law, that law number 8 of 1999 concerning consumer protection, and the company law POJK number 43 2015 concerning guidelines for conduct of investment managers, as well as the code of ethics for financial planners. Jouska as a financial planning company that carry out the business activities outside of the company's goals and objectives stated in the articles of association in the form of conducting investment offering activities and acting as if as an investment manager, Jouska's liability can be imposed admin, administ, administratively, civilly, and criminally. Uh, the basis for consideration in POJK number 43 concerning the code of conduct for investment managers, which is in a sense regulates the behavior of investment managers when they do things that deviate from what has been stipulated in the regulations. In order to responsibility of financial planning companies to consumers who are harmed associated with legal certainty to create their own legal certainty, Jouska can be subject to civil liability by referring to the provisions in the company law and consumer protection law. Corporate responsibility means that any consequences, both good and bad, for the company's legal actions will borne by the company itself. The company law regulates and determines the extent of authority and power of a director. The board of directors, the board of the directors in that company, in carrying out their obligation to manage and represent the company, must be responsible and run it in good faith. The duties, authority, and responsibilities of the board of directors in managing the company are solely limited to the interest of the company in accordance with the aims and objectives of the company. If the board of directors takes action that exceed the limits of their authority or are contrary to the articles of association, then the action is considered as personal behavior to the board of directors and is not act of the company. Directors personally with third parties doesn't bind the company represented by the directors. This is line with what is stated in article um, number 97, paragraph 3 of the company law. If there is a problem with the company caused by an error of the board of directors in managing the company that causes harm to third parties, the board of directors, as the highest responsibility holder in a company, must be responsible. Answer personally. That is that's in the case of the directors of Jouska must be responsible to consumers who use the services of the Jouska financial planning company, which results in significant losses. The obligation of Jouska's directors to be personally responsible to aggrieved customers is trained by looking at the regulation in consumer protection law. If it related to the if it related to consumer protection law, Article 4 states that the rights of consumers who are harmed by business actors are entitled to get compensation if the goods and or services received by consumers are not in accordance with the agreement or not as they should be. Thus, the responsibility of the directors of Jouska personally aims to compensate customers for losses caused by the actions of the directors that exceed the limits of their authority. Apart from being subject to administrative and civil liability, Jouska can also be criminally liable as a last resort. Business actors who legally carry out activities outside the articles of association can be charged with corporate criminal responsibility by referring to laws and regulation and doctrine. Jouska, as a financial planning company, is not authorized to make investment offers and carry out activities as investment managers who make investment offers and manage investment funds and do not have permission from the OJK, then the investment services provided by Jouska are said to be illegal because they do not have permission from the OJK. In this case, referring to the article number 103 uh, Consumer Protection Law, Jouska may be subject to a maximum imprisonment of 5 years and maximum fine of oh about 5 million rupiah, 5 billion rupiah. I mean, and then we get into the conclusion. To Jouska as a financial planning company that attracts investment funds and harms many consumers, it can be held accountable as investment managers are held accountable when they violate POJK number 43 2015. The basis for the consideration of this analysis is carried out through the construction of analogous law in the absence of regulation that specifically regulate financial planners. In addition to referring to the POJK, an analogy is also made to companies operating in the capital market that are subject to the capital market law, consumer protection law, company law, and the financial planning code of ethics, so that those cash should be given administrative, civil, and criminal sanction. I think that's all from me. Thank you for your attention. I hope this presentation and study has given us new insights about illegal. I'm sorry, I mean about the legal protection for consumer in financial technology services. That's all from me and from my partner. Thank you. Assalamualaikum warahmatullahi wabarakatuh.